So it's the first morning after the 49 state attorney general settlement agreement was released, and I've been spending a whole lot of time going through the agreement and reading exactly what the terms of it are. And I can tell you I'm absolutely furious. I was furious last night. The more I get into this, the more and more furious that I get. I encourage absolutely everyone to log on to the website nationalmortgagesettlement.com. I'm going to have the link here, but just Google it, nationalmortgagesettlement.com. And then off to the right of it, you will see all of the settlement documents, including the complaint, and then all of the individual takedowns for the banks: Ally, GMAC, Bank of America, Citi, JP Morgan, and Wells. It's imperative that every single American, especially attorneys, judges, and policymakers, read through this agreement, read through the complaints. The thing that makes me so furious about this is the publishing of this and the settlement of this case acts as if we're breaking some new legal ground here. And there's nothing in here that's new. The thing that should make everyone furious is the fact that all of the allegations that are included within here and all the lengthy recitation of federal statutes and state laws are long existing. All this agreement is a confirmation of what consumers and attorneys like myself and others all across this country that have been fighting these banks have been saying all along, is that the banks and institutions have engaged in grossly irregular, in fact, criminal conduct, and they've gotten away with it. And the thing that makes me so furious is you begin reading, especially the complaint beginning at around line 20, when it details all of the misconduct that the banks engaged in, and they did it repetitively. Make no mistake, and don't get intoxicated by that pitiful number, $25 billion. That means absolutely nothing, to the extent that most of that will be paid from sources which are not directly related to the bank. It's nothing but a payoff to the banks. And in fact, this is nothing but a backdoor bailout to the banks. Our banks are in trouble, and they should be, because of the grossly improper conduct that they engaged in, and yet they are getting, in fact, rewarded for this. Again, I want you to read carefully the allegations made within the complaint and understand that there is a partnership, a two-way street that our government set up between the banks and our federal programs, whether it's the Federal Housing Administration, Housing and Urban Development, or any of the other Federal Housing Finance Administration, or any of the other federal agencies that exist that should be regulating and riding herd over these banks. You and I pay for all of these programs, HAMP and HAFA and Fannie and Freddie and the modification programs, the RESPA, but as a condition of you and I paying for all of these programs and providing subsidies and providing incentives and providing billions of dollars of profits to these banks, they were expected, in fact, they were required under existing law to engage in lawful conduct. What this complaint reveals is they were not engaging in lawful conduct. They were repeatedly and systematically engaging in illegal and unlawful conduct. And as you read through this agreement, you will see a recitation of many of the things. We haven't even gotten to all the things, many of the things that they've gone wrong. But beginning at page 22, the banks and unfair and deceptive and unlawful servicing processes. Yes, all of that frustration that consumers got into when they call their banks and the banks wouldn't have the paperwork to process a modification, and they'd lose it again and again and again, was done purposely, or if not purposely, it was done for gross incompetence. But they indicate in here, beginning at line 22, that they were regularly failing to timely make payments, failing to take adequate possession of the documents. Getting into more loss mitigation at 24, that we are documenting exactly what it was that they were doing wrong. This document serves as a confirmation and proof of the hell that consumers have gone through for years in dealing with these banks and institutions. And what is it that we consumers get after all of this? Once this conduct is as reported, we get nothing. A few paltry thousands of dollars that a consumer might get at some point in time, but in broad terms, you get absolutely nothing out of this deal. What do the banks get out of it? Not only have they been permitted to profit internally by continuing to suck in hundreds of millions, in fact billions of dollars from consumers and private citizens all across this country, but as the complaint details, as a result of manipulating the federal programs that existed, they are being paid to engage in grossly improper practices. You see, as the federal government set up HAMP and HAFA and all these other modification schemes, they provided incentives to the banks. And what did the banks do? They manipulated the incentives so that they collected the money from the federal programs, they collected the incentives, but they didn't follow through with the other side with it, which is to provide the relief of consumers and homeowners. What did homeowners get out of the deal? Homeowners got abused every single day as they spent hours and hours and hours, weeks after months, filing paperwork, sending tax returns, sending bank statements that got flushed down a toilet at each of these servicers. Now, I have a particular interest, as most of you know, in service member and civil relief cases. When the soldiers go off to serve our country, they are due a higher level of respect than a damn civilian like myself. If somebody's going to put on a uniform of the United States military and go out and serve, then he or she is entitled to more respect than a mere civilian like myself. And that is not just my opinion, that's incorporated into law, the Service Member Civil Relief Act. The Service Member Civil Relief Act provides that if you go off to serve your country, the banks and institutions are required to provide certain benefits. But what we find, and what I've certainly found in many cases, is the banks routinely ignored that. So what do we get out of this? Not much of anything. Again, to the extent that what they do is provide some recitation of the facts in here, the fact of the matter is that there's not much in terms of actual penalty that they're required to pay. Now, another of the grossly abusive practices that just blows my mind about the settlement agreement is you have several mentions of the bank's bankruptcy related conduct. Beginning on page 34, you will see where it details some of the conduct that the banks were engaging in bankruptcy court. Here we have banks and institutions grossly abusing federal bankruptcy law, filing improper proofs of claim, grossly abusing federal court system. If the banks are allowed to go into bankruptcy court and abuse the bankruptcy court and walk away with not so much as a slap on the wrist, what kind of country do we live in? We certainly don't live in a country that's based on the rule of law. That's at 34, and it goes into great detail where it asserts that they were filing proofs of claim, motions for relief, or other documents that failed to include documentation related under the bankruptcy code, filing lost note affidavits or other documents that are inaccurate, misleading, or false, filing proofs of claim or other documents where the bank sought payments from debtors that they were not entitled to collect. This settlement agreement is not a statement of law. This is an indictment of the conduct of the banks. Should there have been any question at all about the gross and systemic abuses that the American people suffered at the hands of these banks, here it is right here in a multi-page indictment. Now, in beginning at page 38 is where I would encourage you to look at the violations of the Service Member Civil Relief Act. Again, these are the federal laws that are intended to protect our members of the military, and here we have in direct and specific proof that the banks engaged routinely in conduct which violated the rights of our members of the military. We as the American public, the civilian public, absolutely cannot stand for our dedicated men and women who serve in uniform to be violated in the way that they have. And yet, here we have direct evidence of it, that it was engaging. This entire settlement agreement is a farce. It is an indictment of our legal process to the extent that any of us needed any more proof that the system of laws that we have in this country are failing to protect citizens. This is it right here. Now, when you read all the reporting, the headlines in the national news that'll talk about the landmark settlement agreement, and they'll pick out the best portions of it and somehow suggest that this is good for the American people, one of the things that so offends me about our national news is these headlines that they're picking up that are merely press releases, propaganda presented by the other side. We should be, as American citizens and as intelligent people going to the actual documents and seeing and comparing the documents that are text with what the headlines are, so that we all understand the gross lies and fraud that exist among the mainstream media and what's happening in the real world. Read this document. It's clear language. Now, other things that just frustrate me so as I sit around here surrounded by papers and hundreds of files that we've been litigating for years, trying to convince judges that my consumers have been the victims of bank conduct, and the judges not believing what the consumers have gone through, or even if they believe what the consumers have gone through, not feeling like they have any power or that they should be holding them accountable. We should be doing that. I'm going to post a case here in just a little bit underneath this video, which is stands for the proposition that banks are required to engage in lawful conduct, and when they don't, the courts have an equitable basis to sanction them for that improper conduct. This is what we should be focusing our judges on, is pointing to the terms of the settlement agreement, which specify exactly what it was the banks have been doing wrong for all these years, and that should be used as affirmative defenses in every single foreclosure case. Because the fact of the matter is that this broad national settlement agreement will do next to nothing for the individual consumer. And in fact, for that consumer that's been a victim of improper bank conduct, who might have lost her home because they believed what the bank said when they told them, don't make mortgage payments. If you don't make your mortgage payments, we will put you in a modification, and then shortly thereafter yank that modification out from underneath them and continue with the foreclosure process. The fact of the matter is that they were doing that. It's admitted here in the complaint. Now, how do you raise that in front of a local circuit court judge? I think you got to print up this complaint right here. You have to show the judge this was happening, and then you have testimony from the homeowner that in fact it was happening, and that should be used as an affirmative defense to invoke the equitable power of our local judges and encourage them not to grant foreclosure, not to grant the relief that's requested by the banks in these cases based on their inequitable conduct under the Epstein versus Epstein case. Again, one that I'll publish here a little bit later. This should be a wake-up call to all Americans. They should be petitioning the federal judge in this case, and they should be talking about it, raising the public attention that the settlement agreement should be rejected so that we can get better terms and hold the banks more accountable.